Good morning, ladies and gentlemen, and welcome to episode 16, and I can't believe it's actually episode 16 of our monthly Meet the Experts Q&A sessions with Sintons Employment Team. My name's David Pritchard, and I'm the Head of Marketing here at Sintons. I say it every time, I've said it 15 times, so I will say it the 16th. Once again, thank you for all your positive comments about these sessions, for continuing to sign up to them, for continuing to tune into them, firstly weekly and now as we move them monthly, for sending in your questions in droves, I must say, for us to use throughout these sessions, and for watching the video online afterwards, listening to the podcast version. Very much appreciated. And as I always say, we're glad that these sessions continue to add value to your working week. As with previous sessions, the employment team will answer 3 questions, which I have just popped up there in front of you. Our speakers today: Head of Employment Keith Land and Associate Fiona Campbell. Fiona's going to start, so with any further ado, I'm going to pass her straight over to Fiona, who will deal with questions 1 and 2. Fiona, good morning, and over to you.
Thanks, David. Good morning, everybody, and thanks again for joining us. So the first question that I wanted to deal with was disciplinary procedures. While some things have obviously changed a lot this year, one thing that seems to have stayed the same is people's capacity to misbehave while at work. And we've had quite a lot of queries about disciplinary procedures, and in particular how to make sure that you follow a fair process during these strange times. So while you haven't maybe got the same access to your work site or your employees. So the key point to remember is that even while these weird times are going on, you still need to make sure that you follow a fair process in order for a sanction or potentially a dismissal to be fair. Basically, the same process needs to be followed as has always been followed, and that is make sure that you investigate properly. You then need to make sure that you send a formal invitation to the relevant employee, inviting them to the disciplinary meeting, setting out the allegations, also providing all the evidence, warning them what the potential outcome could be, and also letting them know that they're entitled to be accompanied by a colleague. So in relation to the first part of that process, the investigation, it might be harder than normal to investigate. For instance, people you need to talk to might not be coming into work. They could be furloughed or self-isolating. You can, of course, undertake an investigation remotely. So, for instance, you could have a meeting by Teams or Zoom, or just by way of a phone call. But you do need to ensure that if you want to talk to people about evidence, that they are obviously able to access it. By way of an example, if you want somebody to be able to talk to you about CCTV footage, clearly they're going to have to actually be able to see it. Another issue might be in accessing documents. And please do be mindful that if somebody needs to be given remote access to documents, that you still are complying with the Data Protection Act. Okay, so then the next stage of that process was then inviting somebody to a disciplinary meeting. Make sure that the employee does fully understand the allegations against them, and that they've been given access to all the evidence that you'll be considering when making your decision. The allegations might be made clear by attaching the actual evidence, but make sure that however it's put to the employees, it's sufficiently clear that they can respond to it. I've had a number of situations where, for instance, people have invited someone to a disciplinary to discuss, for instance, lateness or somebody being rude to a colleague. And then what they've done is just simply said, we want to discuss your lateness, or the disciplinary issue is lateness, without actually letting them know when. Clearly, if your issue is punctuality, you need to give examples to the employee. It's not really possible then to prepare for a meeting to explain why on a particular occasion they were late if they've absolutely got no idea what occasion you're talking about. Equally, if someone's alleged they were rude, they need to understand who was they supposed to have been rude to, and when that was actually supposed to have happened. Please be a bit careful as well about bringing up any historic issues. if you've dealt with something informally, you probably then shouldn't be trying to discipline them about it later. What you can do is potentially refer to it as evidence. So you can refer to it back as sort of an example of that behaviour and to show there has been a bit of a pattern. Now, something that's really significant and has come up in specific questions lately is, what do you do if new evidence comes to light partway through a disciplinary procedure? Now, if new evidence comes to light after you've sent out the letter of invitation to a meeting, but before the meeting's actually due to occur, then you can simply send out the evidence and let them know that this will also be considered at the meeting, provided they're given enough time to actually consider that evidence. However, it is possible that new evidence could come to light actually in the meeting. Now, if that happens, what the best thing to do is to adjourn the meeting, make sure they have all that evidence available to them, and then re-invite them to a meeting in a couple of days. It's far better to actually give yourself that extra couple of days, give them that couple of days to consider the evidence, than try to push ahead and potentially make the process unfair. Another situation where you may need to put things on hold a bit is if you realise partway through a disciplinary procedure that actually the issue is not maybe what you originally thought it was. So one example might be that you invite an employee to a disciplinary meeting to discuss potential gross misconduct allegations. However, at the disciplinary meeting, you realise that this evidence isn't probably going to hold up to dismiss by way of gross misconduct. You can't actually make a finding that they have committed gross misconduct. However, the allegations against them are so severe or so potentially embarrassing to the organisation that you may need to consider dismissing them, for instance, in any event, because if it got out that you had an employee who had potentially committed these acts, it would cause serious damage to the reputation of the organisation. Now, the issue there is if this comes up, say, during the meeting, that you realise, oh, actually, it isn't about the gross misconduct situation, it's actually a reputational issue, then you would need to, again, adjourn the meeting. You'd need to send out a new letter explaining, actually, this is what we want to discuss. We want to discuss these reputational issues, and you will be potentially, your employment will potentially be terminated, but for what is known as some other substantial reason, because of the impact it's going to have potentially on our reputation if we don't do that. Now, it's important you do that, because if the employee is turning up trying to explain why they didn't commit the act, they're not ready to explain to you why it won't have an impact on your reputation. So you do need to give them that opportunity to actually be able to defend themselves and explain why that particular sanction isn't appropriate for them. So do make sure that you do give them that opportunity. As I said, it's annoying at the time and you sometimes just feel you want to sort of crack on with the process. But for the sake of a couple of days, it really is worth just sort of putting the brakes on and making sure that you do things properly. As I mentioned, an employee is entitled to be accompanied at a disciplinary. Clearly at the moment that could be tricky, but you do need to still give them that opportunity, and obviously their companion can dial into a call, attend a Teams meeting, or you can still have meetings in person as long as obviously you socially distance. A person can remain on furlough and still participate in a disciplinary meeting, either as the employee is the subject of that or as part of an investigation process. When you then make the decision, make sure you provide enough information so the employee can understand how you actually came to the decision that you came to and what you based that decision on. This is in order that they can actually appeal the decision. It's very difficult for them to appeal a decision if they don't actually understand how you came to it. It also potentially helps later if they were to, say, bring a claim against you, if you're able to show, well, this was our thought process at that time. Do ensure you give the employee right to appeal. There is two different schools of thought really in terms of if an employee has less than 2 years service. because I know that sometimes people sort of feel like, well, it's not really necessary because they can't bring a claim anyway. My view is give them the right to appeal. I'm not sure if all my colleagues necessarily agree with me. I don't know, Keith, for instance, might not agree with that. I'm not entirely sure. But personally, I always prefer to give them the right of appeal anyway, even if they don't have that 2 years qualifying service to bring the unfair dismissal claim, just because it can potentially flush out other issues. So something that maybe seemed like a very straightforward a very straightforward misconduct dismissal, perhaps they then later bring up issues of, say, discrimination that could potentially result in a claim later. And it maybe would have been possible for you to sort of draw a line through them if you had actually given them appeal. So basically, put simply, while a process might need to be changed during the ongoing pandemic, it's vital that a fair process is still followed. If you do need to deviate from your own internal procedures, then make sure you can explain why you had to do so, and ideally have the employee's agreement that you are going to follow a slightly different process than normal, and make sure you keep a note of what you decided to do and why. So that was the disciplinary procedures questions that we've been having, and now I'd like to move on to the notice and furlough leave. And I'll just touch on this really pretty quickly. I wanted to draw your attention to the fact that the updated government guidance and latest Treasury direction has outlined that employers can no longer claim for notice pay while the employee is on notice. So an employee who's put onto notice from the 1st of December, so this relates to from the 1st of December through to the end of January, the employer won't be able to then claim that back. Just to sort of flag up, it's still the case that employers can't claim for any payments in lieu of notice. So as I mentioned, this is the situation for December and up to the end of January. So we will need to recheck what the situation is going to be for February and March, and obviously we'll do our best to keep you posted with that. There is the possibility that your contractual variation when you place the employee on furlough leave did entitle you to still keep the employee on furlough leave at 80% during a notice period, but that will really depend on the wording. So for instance, if the wording of your furlough arrangement says your furlough arrangement will automatically come to an end when we are no longer able to claim this back from the government, then technically speaking, come the 1st of December, if somebody is working their notice, then you won't be able to claim that back for the government, so that furlough agreement would effectively have come to an end. So then in that situation, you would really technically have to bring that employee back to work or pay them in lieu of notice. However, you could simply agree a new contractual variation. It may be that if you offer somebody, well, we would like to still keep you on furlough at the 80%, and we want to enter into a new arrangement to do that, they might be quite happy to do that through their notice, that they may remain at home on the 80% rather than have to come back to work. So it may be something they're prepared to agree to do. In all honesty, the other option really is that you could potentially just carry on and see whether or not they raised it as an issue. If you kept them, you've got your furlough arrangement in place, you keep them off work, and then you wait and see whether they say, oh, hold on a second, I'm not sure if I'm meant to still be on furlough. But you could sort of deal with that as and when that employee raised it. The other point to note is obviously if an employee is on a contract whereby their notice is statutory notice or no more than one more 1 week more than statutory notice, then they will be entitled to a top up to 100% pay for their notice period in any event. So as I said, that was a fairly quick fire answer to the notice and furlough leave query that we've been getting, but I did want to flag up that issue that things will be changing come the 1st of December if you place any employees on notice from then on. So just be wary of that then. And now I'm going to pass you over to Keith to address the sick leave queries we've been getting. Thank you.
Thanks, Fee. As to the appeal, yeah, I think one of the, as to the appeal against disciplinary for somebody with less than 2 years service, I imagine that you and I would hotly debate that one, but I also accept that there's no right and wrong answer, if you see what I mean, and to some degree it depends on a client's appetite to risk, and that's okay. You quite rightly point out that in some cases there have been cases where appeals haven't happened. Had they happened, it would have elicited some kind of further information which would have changed the outcome. Horses for courses, I suppose, is the best way of putting it. Okay, question in connection with long-term sick and things like that. The basic question: can employees on long-term sick who are extremely clinically vulnerable be placed on furlough leave, or should they remain on sick leave, and things like that? And I'm going to expand on it slightly more because we've again and again, Fiona and I have had some fairly heated debate on this topic anyway within the office. Friendly heated debate, should we say? The short answer is in a sense yes, they can be. If they're on long-term sick leave, there is nothing wrong with shifting somebody over onto furlough. What I would say, if they are currently on a period of long-term sick leave and have been throughout the pandemic, I would look at your organisation and I would say, well, okay, make a determination that if that person had been in the building when the organisation was impacted, when you had to furlough other employees of the same position, there is nothing wrong with furloughing them in that scenario. If they're on long-term sick leave and they otherwise wouldn't have been furloughed, I think there is a bit more of a question over it. Because in a sense, would you have done it anyway? Are you just doing it to ensure that you can pay that person a grant that is more than the basic statutory sick pay, or alternatively company sick pay, or alternatively if they've exhausted the right to that statutory sick pay to get some money into their hands? That in light of the fact that they wouldn't have otherwise been furloughed had they been at work, in some respect to me feels slightly uncomfortable, but there is nothing wrong with it in the guide according to the guidance, in my view. And I get Fiona might come back at me. It would depend if you were placing other people in the similar position on furlough. I don't see a problem with that. Just looking at people who are clinically extremely, I can't even get the words out, clinically extremely vulnerable at the current time. We obviously have the position that has been in place, the advice that has been given to those people since the national lockdown, and that's going to change again on the 2nd of December. So at the current time, for people who maybe otherwise were working and who are now clinically extremely vulnerable, the government's advice has been for this lockdown period that they're strongly advised to work from home. So if they haven't been, that's probably where they should be. What the government has also said is if they cannot work from home, they shouldn't really attend work. And so what do you then do with them? Well, if you haven't done anything at this point in time, you probably should have done it a few weeks ago. But these people may qualify for SSP if they can't work. And again, you could essentially furlough them, assuming that they tick the basic requirements, i.e. they're on the payroll they were on the payroll before the 30th of October 2020, and you have a real-time HMRC submission for the last 6 to 7 months for them at some point during that period. I think really it's down to the employer as to what it wants to do with these individuals. And we have had some heated debate within the four walls at Sintons and with our clients as to people who were extremely clinically vulnerable and before the latest national lockdown had actually returned to work, say in September, and then the government advice changed since and they wanted to stay in work. I'll get onto that in a minute because, as I've said, the government's advice changes given the new tiered structure that will be in place on the 2nd of December, and that is more akin to what you should do with somebody now for the rest of November if they're wanting to remain at work. So from the 2nd of December, the advice for clinically extremely vulnerable people is that, again, if possible, they should work at home. If they cannot work at home, they can go to work, whatever tier you're going to be in. OK, so where does that leave an employer with an employee that they know is extremely clinically vulnerable and that person is at work or at the current time is saying, well, I was at work in September and a bit of October. I want to be at work now, thanks. Well, the short answer is you've got to do your risk assessments. You've got to risk assess that employee and the impact of that person's condition and whether they are at greater risk of contracting COVID-19 and having a severe reaction to that. So you're going to have to consider what their working arrangements are, what their personal working arrangements are. Is there anything that you can do to protect that person and perhaps keep them safer than others that don't have that increased risk? So, for example, can you place them in an office by themselves so they're working away from other people? Could you place them in a corner of the building where traffic or people walking past them is not going to be the same? Do you have to ask anyone approaching them to wear a mask? Do they have to wear a mask, and so on and so forth? You've got to consider all of those angles. Your health and safety obligation is to do what is reasonably necessary to protect the health and safety of that worker. I suppose one aspect of that is actually, if you don't think you can adequately protect them at work, what do you do with them? Do you have to actually send them home or medically suspend them? I personally don't think so. You have to risk assess them. Again, I suppose Fee would probably Fee and I would have a hot debate on this topic, I imagine, but my view is you have to risk assess them, and if you can cover those risks by other interventions, then fine. In addition, what you have is a clinically extremely vulnerable person is likely to be a disabled person. So again, you've got to consider reasonable adjustments to alleviate disadvantages caused to that individual. And a disadvantage would clearly be getting COVID-19 and unfortunately becoming very ill. So again, you've got to consider what are the reasonable adjustments you can make to that person's working arrangements, which again includes working at home, other interventions in the workplace if they can't work from home, just to keep them as safe as possible. So as long as you have done what is reasonably necessary to protect the health and safety of your workers, there shouldn't be any kind of criminal liability by the health and safety executive. In the unforeseen not the unforeseen, in the horrible case that somebody gets it, and unfortunately they may pass away if they're in the clinically extremely vulnerable group, whether there is any civil liability attaching to a business comes down to the law on negligence again, and that effectively comes back to, have you done everything reasonably foreseeable to protect that person? I personally find it very difficult that any kind of civil liability for death could attach to an employer, because Just because somebody gets COVID-19 doesn't mean that they've got it from the workplace. They could get it from their supermarket. They could get it from the food that is delivered by the supermarket to their home. They could get it when they go shopping. They could get it from anybody. That they could get it from one of their family. I find as a legal issue, it's going to be very difficult to point to an employer and say, well, I definitely got COVID-19, and so their relatives sue their employer, unless, of course, there is a breakout within a workplace. But if you are following the COVID safe guidance, you should be okay. One thing that has come up is the position of your employer's liability insurer. Particularly at the current time, where the advice is that the people who are clinically vulnerable should stay away from the workplace. Some insurers that we're aware of have taken the position that so long as the employer has a risk assessment, it's down to a decision of each individual employer. Other insurers have taken a much harder line, which if they've said those people should not be in the building, and consequently they can't come to work. At that point in time, those people would be uninsured. You're going to have to take steps to say to them, sorry, you can't come into the workplace at this point in time. So I think as a safety net, you should probably strike up a dialogue with the insurer if you haven't already done so, and also do so from the 2nd of December. There is more flexibility in the guidance that is coming in the new tiered system as from the 2nd of December. So I imagine your insurer will then shove it back into your lap, i.e. you risk assess, you take that decision. But it will be worthwhile striking up a dialogue, because if the worst happens, you don't want to be uninsured. What I would say is an employer, an insurer in those circumstances, I don't think that they can deny liability in a sense. But if they are saying somebody shouldn't be in the building because of the risks, you have to listen to that. You would then be falling back on perhaps furlough. Again, if it's an employee saying, well, I don't want to be furloughed and I won't agree to furlough and I want to come in, and you have to say to them no, then you're probably into the territory of medical suspension, which would be sending them home on full pay. However, what I would suggest is if you're into that kind of impasse with an employee, the best thing you can do is speak to somebody like us and get some advice. That's what I have to say on that topic. I'll probably leave it there. I'll pass you back to David in a second, and I will then go off, and Fiona and I will argue about what we've just said for the rest of the day. Thanks for listening. I think, if I'm not cutting across anything that David said, and I don't know if we've put one in the diary for December, David, but I was going to say it's possibly a short month, so maybe we should skip and see everyone again in January, but I don't know if we have the date in the diary yet, and no doubt David will tell me if I am wrong. Thanks very much.
Thanks, Keith. We do, and I'll come on to that in a moment. I just want to say and just state the pure joy I felt today of watching Keith present with a headset on. After he's been such a fan of my headset for the past 8 months of us doing these sessions. So just wanted to say that. Quick reminder for me on content. We're working really hard to continue to produce and deliver useful and relevant content to you. Articles, blogs, podcasts, all of these previous sessions, all of these Q&A sessions, all can be found on our website, www.sintons.co.uk. Social media, you can follow the employment team on Twitter at SintonsHR. Just popped Fiona and Keith's details on the screen there. Please don't hesitate to get in touch with them if there's anything they can help you with, anything you wish to discuss. As Keith says, with Christmas on the immediate horizon, our next session will be Friday the 29th of January 2021 at 10 AM, and I will send the link round as usual for the next session in due course. So from all of us at Sintons, once again, thank you very much for listening. It seems a bit early to wish everybody Merry Christmas and Happy New Year, but as we're not going to speak to you via these sessions, we'll do that. Please continue to stay safe, enjoy the festive season as much as you possibly can, and we look forward very much to speaking to you again in 2021 and throughout 2021. Thanks very much. Take care.